Good morning. I'm Gary DeWaal, and this is Bridging the Week for November 19th through 30th, and today is December 3rd, 2018. The Securities and Exchange Commission's view that most crypto assets issued as part of initial coin offerings and pre-sales to ICOs are securities was challenged by a federal court in California, which denied the agency's request for a preliminary injunction in an enforcement action against an individual and his company that purportedly defrauded investors in connection with a digital assets ICO. The court held that the SEC, at least for now, had not demonstrated that investors in the relevant crypto asset expected to profit through the efforts of others, a key requirement to demonstrate that an investment is a security. Unrelatedly, the Chicago Board of Trade penalized an individual over $100,000 US for engaging in 3 different types of spoofing activities. It's hard to believe that December has crept up on us so quickly, so I can hurry outside to enjoy all the season's decorations and celebrations. Let's get started. A federal court in California declined to impose a preliminary injunction against defendants accused by the SEC of engaging in a fraudulent and unlawful offer and sale of securities, stating that the SEC had not demonstrated that the crypto assets purchased by investors were securities under applicable law. Previously, the SEC obtained a temporary restraining order against the defendants, Blockvest LLC, and its chairman and founder, Reginald Buddy Rignold, claiming that the defendants engaged in fraud and the offer and sale of unregistered securities, crypto assets called BLVs, that initially were sold through pre-sales to initial coin offering and an ICO. According to the SEC, the defendants falsely claimed that their ICO received regulatory approval from the SEC and that Blockvest had a relationship with Deloitte, a public accounting firm, when it did not, and made other material misrepresentations. The emergency order froze defendants' assets and temporarily prohibited them from violating anti-fraud laws. In response to the SEC's application for a preliminary injunction, the court noted that it could only grant such relief if the SEC demonstrated a quote-unquote prima facie case of a prior violation of federal securities laws and a quote-unquote reasonable likelihood of a repeat future violation. The court said the SEC satisfied neither of these elements. The court held that the SEC did not show a prior securities law violation because, among other things, it did not demonstrate that the relevant crypto assets were securities. This is because the SEC failed to demonstrate each of the 3 prongs of the so-called Howey test necessary to evidence that an instrument is an investment contract, a type of security. These elements are that an investment of money in a common enterprise with the expectation of profits accomplished through the efforts of others. Among other reasons, the court concluded that the SEC provided, quote, no evidence, end of quote, to support that investors expected profits, meaning capital appreciation derived from the development of their initial investment or a sharing of earnings generated from the use of their invested funds. During September 2018, a federal court in Brooklyn, New York, declined to dismiss a criminal indictment against Maxim Zaslavsky, charging him with securities fraud and related offenses in connection with 2 cryptocurrency investment schemes and their related initial coin offerings. There, the court held that the Department of Justice had made sufficient allegations to demonstrate that the relevant crypto assets issued as part of ICOs were securities. The different outcomes between the Blockvest and Zaslavsky cases, although resting on different preliminary presentation of facts, may herald an ultimate determination by a higher court as to what the expectation of profits accomplished the efforts of other leg of the Howey test actually means. Although the Department of Justice and SEC have repeatedly argued that crypto assets issued as part of pre-sales to ICOs and ICOs are most often securities, investors in such digital assets do not typically expect to share any income from the project identified with the ICO, and the value of the crypto assets only remotely, if at all, is tied to the value of such project. Moreover, investors in digital assets will likely have no claims on the assets of a project if the project goes bankrupt. Investments in digital assets in orange groves managed by promoters of the investments at issue in Howey are very different than these items. It has always seemed to me that crypto assets that the Department of Justice and the SEC claims are investment contracts are more likely collectibles traded among enthusiasts than securities. Let's see. CME Group Exchanges brought and settled multiple disciplinary actions alleging disruptive practices, wash trades, and position limit violations. Timothy Roach, a Chicago Board of Trade member, resolved a disciplinary action by the exchange by agreeing to pay a fine of $90,000, disgorging profits of over $11,000, and serving a 30-day all CME Group Exchanges access prohibition for purportedly engaging in 3 types of disruptive trading practices from February 1st, 2016 through May 3rd, 2017. On some occasions, said the Chicago Board of Trade, Mr. Roach entered multiple layered orders on one side of the soybean futures market to induce executions of a smaller order on the other side. As soon as he obtained execution of the smaller order, he canceled his opposite side orders. On other occasions, claimed CBOT, Mr. Roach entered orders on one side of the market at the best bid offer, and as other traders joined his resting orders, he used self-match prevention software to cancel his resting orders and to trade opposite the other resting orders. Finally, on one circumstance, Mr. Roach modified the price of a pending iceberg order to trigger self-match prevention software to cancel various layered offers he had placed on the other side of the market, which had also attracted other traders' interest. Unrelatedly, Gregory Cofford agreed to pay a fine of $25,000 to the Chicago Board of Trade and serve a 15 business day all CME Group Exchanges trading prohibition for matching buy and sell orders of accounts for the same beneficial ownership in U.S. Treasury bond and corn options markets. The Chicago Board of Trade also claimed that for half of his orders, he used a Tag 50 identification other than his own, contrary to the exchange's requirements. And finally, Martin Russ, a non-member, agreed to pay a fine of $20,000 to resolve a disciplinary action brought by the Chicago Mercantile Exchange. CME alleged that on June 22, 2018, Mr. Russ violated position limits in June 28 live cattle futures contracts. On the next trade date, he liquidated his positions that caused his violation. According to CME, he did not profit by his trading. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out at www.bridgingtheweek.com. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao!